Mr. Martinez-Fraga is the co-leader of Brian Cave's International Arbitration Team. In 2015, he was appointed by President Barack Obama to be the U.S. delegate to ICSID. He's represented 9 countries in arbitration proceedings around the world and has been published in 15 countries and 5 languages. Mr. Reetz is the managing partner in the office of Brian Cave. He graduated from Harvard. I won't say when. He's an alumni. He's the chair of the Miami International Arbitration Society, and he represented clients in ICSID, ICC, and ICDR proceedings, among others. They're here today to talk about their book, Public Purpose International Law, and How to Place International Arbitration. And we're very, very happy to have them here. Please join me in welcoming them.
The time I've spent in court and in tribunals, I'm used to shouting without a microphone. I apologize for the clumsiness here. Thank you, Christian, so much for the very kind introduction and for the very kind invitation to be here today. It's really exciting for us. We're thrilled to be here. And in talking about public purpose, one question that many of you might have is whether there's really anything to discuss on the topic. Is there room for different views on the subject, or is public purpose simply something that we can all agree upon, finish lunch, and go home? And in thinking about it, I'm reminded of an old joke from the Soviet era, which I hope will make sense to you, because that's a long time ago. That's back when I graduated from the college. But the story is that there's a militiaman standing out in front of the Kremlin. And someone drives up, and what for a private individual would have been a very nice car at the time, and actually parks on the sidewalk in front of the Kremlin. And the militiaman runs up and says, "Are you crazy? There's a whole government in there." And the driver said, "Don't worry, I've got very good locks on my car." The point of the story, is that people have different perspectives on the exercise, on the use of power by the state. And public purpose seems to be an interesting doctrine to look at in that context. So to begin, what is public purpose? It's not the same as public order or public policy, a doctrine that you've probably seen a lot of during arbitration. The latter doctrine, public policy, has a wide range of application, but we usually think about it as a limit on what the state will permit. A limit on what the state will permit. For example, will the state allow the enforcement of a foreign judgment or arbitral award? Or will the state give effect to an agreement between private parties? In contrast with this idea of public policy, public purpose is more focused on the proper objects of state action. What may the state legitimately do? Where do we find the doctrine? Well, we find it in various aspects of international law. I think Pedro will mention today, for example, that the idea of public purpose is embedded in international human rights law. It's mentioned in the law concerning permanent sovereignty over natural resources, for example. But what's most relevant to our own practice is the appearance of the doctrine in investor-state law. Where do we find it? In the law of investor-state protection. We find it in 2 contexts. First of all, and most obviously, is the doctrine of when an expropriation is legitimate. You may have seen that a state may only expropriate property under customary international law and most treaties where the property of non-nationals of the state, where the expropriation is for a public purpose, where it's done in a non-discriminatory manner, where it is in accordance with due process of law, and where fair and adequate compensation or some measure of compensation is paid. And so the first requirement of this formulation is that the expropriation has to be done for a public purpose. We tend to skip over it and focus on compensation, which is what the lawyers are all about, but it is a requirement for an expropriation to be legitimate. And we see this formulation of the expropriation doctrine and the requirement of public purpose in bilateral investment treaties, multilateral investment treaties, now trade treaties, investor protection agreements, as well as customary international law. Where's the second place that we see public purpose in investor-state protection law? We see it in the context of indirect expropriations and the question of when is state action, in fact, an expropriation. The indirect expropriations, as you're probably familiar with, is where the government doesn't necessarily take over title to property. It doesn't say, I own this now, but it impairs the use or value of the property to such an extent that the investor's interest in it is very substantially diminished. So we see that, and that's also an area that Pedro will talk about in a little more detail. The extent to which activity is done for a public purpose may affect whether the state activity is considered an expropriation at all. Is public purpose defined anywhere? We've looked at a whole lot of treaties, and we've looked at a lot of commentary, and with very few exceptions that really are far from being generally accepted, the concept of public purpose is not defined anywhere. It's perhaps like the old definition of pornography, you're supposed to know it when you see it. But we don't have it defined in the treaties. We don't have it discussed in detail elsewhere. There is a general historical viewpoint as to what public purpose is. And we'll talk about that in more detail. The general historical viewpoint is that public purpose is whatever the state says it is doing in furtherance of its own ends. Public purpose being whatever the state says it is. What are the consequences of public purpose? We've talked about its appearance in investor-state protection law. And there are two main consequences in the investor-state field. First of all, we talked about public purpose as a requirement for an expropriation to be legitimate. And this has been interpreted by a number of tribunals to mean that if an expropriation is done not for a public purpose, then the expropriation has become an illegal expropriation, and the amount of compensation to be paid may be a more generous measure of compensation to the investor. For a legal expropriation, you may have to pay only some sort of adequate compensation. For an illegal expropriation, a higher level, maybe a just compensation or full compensation. And the second consequence of whether a taking is for a public purpose or state activity is for a public purpose is whether, is the effect, arguably, on whether the taking amounts to an illegal expropriation. So I've given you a historical view. Public purpose is whatever the state says it is, and two consequences in the investor-state field, damages and expropriation. Is there really anything left to discuss, or can you go home now? We think, yes, there is something to discuss, because the very broad historical view of public purpose, which could apply to any state action. The state does something and says, yep, that's a public purpose. If we accept that definition, then the consequences of something not being for a public purpose would never come into play. The state's never going to say, I did that and it wasn't for a public purpose. Ha ha. The state's always going to claim public purpose, and if so, if we accept that the state can always say that something for a public purpose, then we never have a non-public purpose, and those consequences are illusory. And this is recognized in some of the commentary, including the restatement of the law of foreign relations, second and third. So this problem with the broad definition of public purpose leads us to a choice. We can either accept that public purpose is essentially meaningless. It's language in the international instruments that I mentioned. It's found in the bits and the bits, etc. But it's meaningless because it's a test that will always be met and therefore has no consequence. Or we can try to arrive at a deeper understanding of the doctrine, something that goes beyond the traditional historical legacy view, and see whether there's a way to give the doctrine some content, and see whether the doctrine in its current form really adequately addresses the needs of the international system. In other words, although the doctrine is historically viewed as a self-judging test or principle, is that appropriate in a world that has become highly interdependent? And so Pedro and I decided we would try and look in the doctrine. We took the fork in the road, so to speak, in terms of trying to understand it, and we decided to look at the doctrine from three different perspectives. First, historical. What is the traditional view? How was it developed? Secondly, descriptive. How is the concept viewed today and in what context? And are there other contexts that we can look to for a deeper understanding? And finally, prescriptive. What should the doctrine be? What should it say? We found it's not an isolated concept in investment law, as I mentioned, that it appears in various other strands of international law. We also identified a number of concerns with the doctrine as it's currently formulated and applied, and came up with a number of suggestions as to how to improve treatment of it, none of which sadly have been adopted to date, but that's why we're here. And so at the risk of sounding like a BuzzFeed headline, here's what happened next.
Thanks, Ryan. Thank you, Christian, and thanks to all of you for being here. Let me first share with you 4 points on the book and on public purpose, which are 4 fundamental premises that serve as a framework for our analysis of public purpose. We think that public purpose, important as it is, ubiquitous as it is in public international law, it has a place actually in over 3,000 bilateral investment treaties, of which 2,060 have actually been signed and are in effect. Despite the literature talking about there being over 3,000, reality is once you pass 2,060, all the others are not in effect, and only about 160 of those were ever in effect. So they affect the empirical formula of what's any inferences that you draw from those bits. But we have 4 propositions, and the first proposition that we subscribe to is that public international law has to be accountable to itself. And what do we mean by this? That public international law has to be based on its policies, its objectives, and the core concepts of public international law. And our perception is that with a number of public international law principles, for example, the limitations period in public international law, certainly public purpose in public international law, umbrella clauses in public international law, and most favored nation clauses in public international law, within the context of investor-state arbitration and the public international law of investment protection, these concepts have been, in many ways, disavowed by international law. Why? Because they've been based on very territorial, parochial, national principles. So you have the law of contract, the law of property, the law of torts, somehow engrafted into protection standards contained in these bilateral investment treaties. And our suggestion is that this is very bad, that this does not help a community. It served us well when we had a model of independence and where we had no globalization. But as we move to a model of interdependence, where international law is now transnational law, the law shared by all nations, and not just the relationship between 2 nations, public international law has to be true to itself. And what do we suggest? We suggest that being true to itself is very specific. It has to be, for example, in the field of international investment arbitration and international investment law, it has to take into account microeconomic concerns. What does that investment do at a microeconomic level? And how does the protection standard affect it? How is the exercise of regulatory sovereignty affecting this investment? The same analysis has to take place at a macroeconomic level. It's also very important. The distributive effects of foreign direct investment and the budgets and the internal economies of states also have to be taken into account. One of the Czech Republic cases gave rise to an award that was 3 times greater than the Czech Republic's budget for healthcare for 5 years. This has to be taken into account. The chilling effect of bilateral investment treaties and the interpretation of standards of protection also have to be taken into account. With public purpose, the doctrine has been completely severed from any of these considerations. In fact, you'll be shocked when we tell you where it is that we think that the doctrine actually comes from. That's the first proposition. The second proposition that we feel is very important is this. In the field of international investment protection, two principles have been wrongfully confused. Towards the first quarter of the 20th century, it became common understanding that states are allowed to expropriate. States, in the exercise of their regulatory sovereignty, can expropriate. And there are many decisions on this point. It's not really, it's beyond quibble, really. But here's where the confusion comes in. While states can expropriate, there is absolutely no evidence in the law of treaties that states may set the terms and conditions of expropriations. I'll repeat that again. There's absolutely no evidence in treaty law, in any of these 3,000 bilateral investment treaties, in any multilateral treaties, that states can set the conditions for expropriations. In fact, the opposite is true. When you read these treaties, when you read, for example, the first bilateral investment treaty ever was the 1959 bilateral investment treaty between West Germany and Pakistan. And when you read that treaty, you find many things are strange about that treaty. That treaty is very typical of treaties that were negotiated with asymmetries between the capital exporting state and capital importing state, the host state. And that treaty has some anomalies that are curious. But when you look at public purpose in that treaty and expropriation, you'll find that it has an expropriation provision, and that expropriation is tempered by a public purpose requirement and just a compensation requirement. It doesn't have any of the other requirements that you would expect, like, for example, discrimination as being a requirement, and due process, the other two elements. So that we see that states are very generous with their understanding of how it is that they can expropriate, when in fact the law is completely contrary to this. There's a third proposition that's very important to us, which is that we feel that states should and must affirmatively demonstrate before international tribunals what public purpose they are furthering when they engage in a taking. And this should not and cannot just be a visceral, intuitive, what the state says is right. What the state defines as public purpose constitutes public purpose. Finally, the fourth proposition on which the book is based, I think is an extremely important one, which is what is the role of public purpose with respect to international human rights? And if you think about it, what public purpose in its legacy intuitive form does is it amplifies the state's ambit of regulatory sovereignty. It says to the state, I can do this in the name of national security, I can do this in the name of environmental concerns, I can do this in the name of prudential measures for an economic system or banking regulations. That's what it does. It's the general over the specific. What does international human rights, what do these rights actually do? Well, what they actually do is it provides the individual with standing against the state. It pits the public purpose doctrine against the rights of the individual vis-a-vis the state. If you have the legacy public purpose doctrine and you take three basic human rights conditions, the African Charter on Peoples and Human Rights and People's Rights, the American Convention, and the European Convention, and you use a visceral public purpose, the legacy public purpose analysis there, you'll find that public purpose is public purpose completely overwhelms human rights. You can't square the circle there. It's just not possible. You need a public purpose that is actually substantive. You'll also find that public purpose is tempered by our proposition of what public purpose should be. How is it tempered? Well, public purpose, one of the things that it does is it shows us different categories of different human rights. The right to assembly, For example, we can see how you can use, under some circumstances, public purpose perhaps to qualify that right in certain instances. But can public purpose really be used to temper or qualify the right to be free from torture? Can it be used, public purpose, can it be applied to somehow qualify the right to have a name or the right to children? We say it does not. But in order to have a conceptual framework that works, public purpose actually has to have some meaning. Now let me that's a little bit of the descriptive in front of the historical. Let me tell you where we are with public purpose. If you look at the restatement second on the U.S. law of foreign relations, and then you look at the restatement third, the restatement second, I think, dates to 1965. The restatement third dates to 87, but it's the current restatement, so it's whatever, 50-some years old. It's still in place. The restatement will say that public purpose exists, but if it's of no moment. It cannot be defined at all. If you see the cases, the tribunal cases, the Iran-U.S. claims tribunal cases, or the Libyan tribunal cases, oil cases, you'll see that public purpose is raised and public purpose is completely discarded. If you look at the Anglo-Iranian case, which is the UK case against Iran, which is probably the first and last pronouncement that the ICJ had on a nationalization case, you'll see that the UK, the claimant in that case, never even questioned whether public purpose had been violated. It just took that for granted. Of course, that case was dismissed on jurisdictional grounds, but if you look at the record, public purpose was never identified by the claimant as an issue. Why is this? How did we get here? We look back, and this is a historical point, and we started tracing public purpose, and we first found public purpose in Homer. Homer uses a word called demos, in the feminine demus, which means, strange what it means, it's used to describe slaves. And it uses public purpose as a way of justifying the creation and the taking of demos and demus. In other words, Homer uses a word that loosely translated translates into plunder with feet. And it says that plunder with feet can be taken for purposes of furthering the public purpose of the city-state. That word later mutates a little bit with classical Greek. It turns into anthropodon. You can see the root very close to anthropos and aner, the words that we're familiar with. And there it literally means chattel with feet. And that's how public purpose started being applied, with the better interest, the public purpose interest of the state being able to take human chattel, plunder with feet, and to appropriate it and to justify it based upon what was understood as being a public purpose. This was an inward-looking way in which Athens viewed these matters, which is very tied up to the parochialism of language, the parochialism of the city-state. You may recall that particularly with respect to the means, the Athenians developed a word that we use today, barbarians, but that word really was barbaros, which was a way of expressing everything that is not Greek. In its verbal form, barbarzarein, in its infinitive form, it meant more like everything that's not Greek is speaking gibberish. That's the way it sounded to the Greeks, gibberish speakers. And there was only one type of exception for being able to respect an individual and not be able to enslave, justifying on a public purpose. And it's very interesting, this one exception is tied up to two things: the word for treaty and the word for libations to the gods. And libations to the gods is something very, very known to students, I know, but these libations are the libations that were served to the gods at the conclusion of treaties. The word is spondai, and it's en spondon an exponent of it. When you're a signatory to the treaty and you're not a signatory to a treaty, if you belong to a party that's a signatory to the treaty, then you cannot be taken. You cannot be enslaved as a matter of public purpose. This was the culture that really developed, and I hate to read from notes, but I will, because in his book, which is kind of like a chestnut of international law, Wheaton writes this about the Greeks. And again, I hate to say the Greeks because the Athenians are not the Spartans and the Medes, and they're different, but please excuse me. It says, this is Wheaton. He says, quote, Thucydides has correctly stated the leading political maxim of his countrymen, quote, that to a king or commonwealth nothing is unjust which is useful. The same idea is openly avowed by the Athenians in their reply to the people of Melos. Aristides distinguished in this respect between public and private morality, holding that the rules of justice were to be sacredly observed between individuals, but as to public and political affairs, a very different conduct was to be followed. He accordingly scrupled not to invoke upon his own head the guilt and punishment of a breach of faith, which he advised the people to commit in order to promote their public purpose. The doctrine of public purpose became everything that we say it should be. It became self-judging. It became intuitive. The thinking was that if it was submitted to discursive reasoning, the only thing that discursive reasoning would do would be to cloud it. If you look at the opinions from the ICJ and the PCIJ, you'll find that public purpose is referenced. It's referenced in the 1926 opinion of Germany against Poland, in the German interest in Upper Silesia. And it was German, and it was also mentioned in the, and I'm butchering the pronunciation, the Schorsel case, Germany again versus Poland in 1928. Both references, however, were fleeting, just fleeting references to the state being able to expropriate, but subject again to public purpose. What do we say? We say public purpose cannot be self-judging. Public purpose needs an objective standard. Public purpose has to be subject to the doctrine of proportionality. It cannot be an all or nothing proposition. And public purpose has to be modified to meet the objectives and policies of public international law. So where did we go to study public purpose, to see how we can find public purpose in some sort of model or paradigm that we can take apart and build from? And we looked at the NAFTA as providing for the perfect model. Why? Because the NAFTA has a mixture of international commercial law and the international law of investment protection. Although I understand that the NAFTA with 22 chapters, 7 annexes, and 8 parts, it only has 2 chapters on investment law. And those 2 chapters are qualified such that if there's any internal conflict between the international law of investment protection and commercial law will govern. But the NAFTA, precisely because it has both together, we thought it was very, very important. It's a microcosm of public international law. The NAFTA also has what? Its own jurisprudence, its own cases. It's very jealous about the tribunal awards that are NAFTA tribunal awards. So it has a whole body of jurisprudence, if you will, all being non-binding, that was very, very helpful. Also in section 1101, subsection 4, the NAFTA has a standard. The drafters of the NAFTA had the vision of not defining public purpose, but actually subjecting public purpose to a standard. And this was also a great point of departure. This was very helpful. We looked at the case law, we looked at Methanex and Metalclad and all the other classical cases under the NAFTA. And what we found was extremely disturbing. The standard helps, to be sure, but at the end of the day, it creates more problems than it could ever seriously aspire to resolve or answer. The NAFTA then goes on and provides you with a list of public purpose reservations, if you will. And what these reservations do, it just completely broadens the framework of the scope of the state's regulatory sovereignty. The state can basically do anything in the name of virtually every conceptual category that touches or concerns a geopolitical subdivision. That's totally not helpful. The reservations in the NAFTA, what the three parties actually agreed to keep as special grounds for exercising regulatory sovereignty are not helpful conceptually, and this is why. Even though the methodology is objective, it's a clear procedure, very positivist, if you will, procedure for reaching these reservations, the subject matter is idiosyncratic. It has to do with the negotiation process of the three states. So ultimately, that was wholly and completely unsatisfactory to us. So the NAFTA as a model teaches us several things that are important. First, that the NAFTA itself lacks a hierarchy of public purpose. Second, that the NAFTA, in setting forth a standard, does not set forth a standard that adequately and comprehensively helps with trying to provide an objective type of public purpose. The NAFTA case law is problematic for this reason. If you look at the two cases that I mentioned earlier, Metalclad and Methanex, both are exquisite cases, and they were very, very important cases when they came out. But they're conceptually at odds with each other. The effects test that came from the NAFTA is equally problematic. In some instances, it's almost like a strict liability standard that cannot be resolved. And again, public purpose plays only a nominal role. It doesn't really move beyond just simply articulating that there is a state right and to act beyond just expropriation, where the investment can be diminished. It doesn't help us much beyond those very general propositions. So where are we left? Simple. We're left in a situation where public purpose now has to draw from the policy objectives of public international law, where law and economics has to play a protagonistic role in fulfilling what public purpose is, where public purpose has to be taken seriously as a substantive element that does create a chilling effect for the exercise of a state's regulatory pronouncements. We have to also qualify public purpose. Public purpose cannot attach to all things public. Public purpose cannot be all things that the state says it is. Now, I'll share something with you. Our proposition, our aim at looking for a public purpose that is universal, transparent, not self-judging, substantive, is not an easy one. The former dean of a law school, I forget the name of the law school, I think it has to do like with a key or a lock or something like that, I'm not sure. Harold Coe, and former chief advisor to the United States Department of State, said that when we wrote this book, we quoted and cited to Kant's work, Peace Through Law, and said that where we ended up somewhere in the space of Hobbes and the Leviathan. That we went from one extreme to the other extreme. I'm not sure that he's right. I will tell you how we really did end up the book and the analysis. We cited to Ovid in the Metamorphoses. And there's this beautiful passage in the Metamorphoses where Aeneas is confronting a spirit. And Aeneas asks the spirit whether he can pass through the gates of hell, if you will, so that he can see his father's shade. And the spirit says, Aeneas, you're a brave man. You've shown tremendous courage in battle. And he uses the phrase, nulla via in via virtuti est. For virtue, no path is impossible. Of course you can rejoin and visit your father. And we feel the same way. It'll take a lot of steps to try to bring transparency to this field of law that we love so much. And it'll be very, very hard But it certainly is not going to be an impossible task. I want to thank you for being so patient and gracious with your time and attention. I'll turn it over to Ron.
Well, I think Pedro's given you an excellent preview of what our suggestions will be, and far more poetic than I can. But we do have a number of recommendations for future analysis and development of the doctrine. And perhaps a point of departure is another old Soviet-era joke, in which a nervous man walks in to the KGB office one day and says, "My parrot has been stolen." And the official behind the desk looks at the man and says, "This is not a matter for us. This is a matter for the criminal police." And the man says, yes, I know that this is a matter for the criminal police, but I wanted to come here and tell you officially that I disagree with that parrot. And we disagree with the historical development of the public purpose doctrine. We think that change is needed, and we're here to say that officially. So what do we think can be done? We have 11 prescriptive recommendations for further development of the doctrine, and I think you probably can infer most of them from what's been said thus far. But first of all, that public purpose is not a self-evident proposition. It's subject to reasoning, to discursive reasoning, as Pedro said. If we can't think about it, if we simply have to accept it, then the doctrine does no good, it has no purpose. Second of all, is that just because an act or activity is public in nature does not mean that it has a public purpose. You may think in terms of foreign sovereign immunity doctrine, where you have commercial acts and sovereign acts as perhaps an example of that. But just because the government does something, or it's a public act, that doesn't necessarily imbue it with a public purpose for purposes of this doctrine in international law. Third, and closely related to the first point, is that this should not be a self-judging standard, a standard where the actor gets to say what the purpose is, and that must be accepted. It has to be subject to objective standards, objective analysis, in order to determine whether there really is a public purpose behind the challenged act. Fourth, in addressing the doctrine and going forward with the doctrine, this is something that can't be done by individuals or by single governments or even more broadly. It really requires collaborative efforts and compromise on behalf of the international community as a whole. All of the, to use a phrase I hate, stakeholders in investor protection law, for example, need to be willing to engage with the doctrine, and there needs to be a balancing of interests. This can't be a win-lose definition that always benefits the state or always benefits the investor. There has to be a balance. Fourth, it's important to, fifth, for those of you who are keeping track, it's important to recognize that many sources can be helpful in developing the doctrine further. That we tend to go to the same sources. What's in the treaties? What have the commentators said? But there are sources such as the foreign investment protection laws that many states have passed that may be very helpful in trying to arrive at an understanding of what is public purpose, what is the scope of legitimate regulatory sovereignty, and other materials that are not traditionally consulted, such as the UNCTAD reports on investment law. Sixth, it's important to seek to harmonize the doctrine of public purpose, at least within a particular field of law, so that if the phrase has a different meaning in every treaty, and there are arguments why perhaps it should, but if we don't arrive at an understanding that has a core concept of public purpose, both in investment protection statutes, in treaties, and in other instruments, and in customary international law, we are moving further away from our goal of having a coherent doctrine. Next, we don't think that public purpose is necessarily a binary question. On or off, yes or no, it is or it isn't. It has to be considered in context, and perhaps what's been lacking from many of the decisions is a proportionality analysis. Is the asserted action relative to the asserted goal, the asserted purpose, proportional? Does the asserted purpose make sense in terms of what the state is legitimately trying to accomplish? Next, there might also, in addition to the idea of proportionality, there might be a hierarchy of public purposes, some of which are more important than others. Protection of human life is probably a lot more important public purpose than some others that have been asserted, for example. Next, and we think this is important and really an easy place to start, is that public purpose should not extend to conduct that is merely political in nature, such as regime perpetuation or political indoctrination. It's important to distinguish between politics, political ends and goals, and the role of the state. And a state that, for which the state occupies the entire field of politics and there's no distinction between the two, we don't think that that's an acceptable articulation of public purpose, that all political things are public purpose. Next, and next to last, is that states should begin to try offering standards, as in the NAFTA, or even definitions of the term in their agreements. It can give them greater certainty, greater predictability, and not incidentally can help in development of the doctrine. Of course, that's a big ask, but it will benefit states if they're willing to approach the doctrine more directly, and unless they hope that it simply remains self-judgment forever. And then finally, in looking at the question of public purpose in the context of these disputes, there are additional collateral doctrines that need to be developed. There are issues such as burden of proof, presumptions that ought to apply with respect to public purpose. For example, we suggest that the burden should always be on the state to establish its public purpose in acting, and to do so clearly by I hate to use U.S. common law terms, but maybe clear and convincing evidence rather than a mere preponderance of the evidence, by a higher evidentiary standard than merely barely squeaking past the persuasive gate. So those are our 11 suggestions for the doctrine. As I said, none of them have been adopted. I'm not sure that any of them are going to be soon, but we're hopeful. And we think it's useful and productive to discuss the doctrine, to try to develop it further, unless foreign investors are simply going to rely on the investment equivalent of having better locks on their cars to keep the state away from them. So thank you very much for your patience, and it's been a pleasure.
Maybe we can take some questions, if you guys are right with that, and then I know some of you might have class soon, so please feel free to slip out.
Thank you very much for the talk. Question, is there currently, would you say there is currently an international minimum standard for what public purpose means, and should we have one? Because as I see it, public purpose is very difficult to generalize. Of course, if a treaty has a public purpose, the term public purpose, it has to mean something, but I would say you cannot really know what it means unless you have the facts. It's different from other terms. This public purpose is particularly general. So you know it when you see it, but it's hard to speculate beforehand what does it mean. So would you say, is there a minimum standard?
There appears to be a definition, a working definition of public purpose, which actually the restatement commentaries pick up on, the restatement of U.S. law and foreign relations. And it seems to be that in the context of an expropriation, if the subject matter of the expropriation is transferred to private hands rather than to the state, that is a clear violation of public purpose that has been universally recognized. Beyond that, every permutation of public purpose that you can imagine has been raised as an argument. And for example, in the BP case against Libya, it was argued by BP, by British Petroleum, that in fact the taking was politically motivated and bore no rational relationship to the state, etc. But still, nothing came of it. So the answer to your question, yes, when the subject matter of the expropriation is transferred by the state to private hands. Which is not satisfactory, I suggest.
Very, very rich talk. I have maybe two quick questions. First is just from a treaty negotiation perspective. Are you against carve-out entirely? What's your view on carve-out?
I'm for carve-out. I think carve-out works. Here's the assumption, however, that is problematic. In treaty, and we do a lot of this work, what I find in treaty negotiation, in the practice of treaty negotiation, is that it's assumed that a treaty negotiation is very much like a commercial transaction having to do with a willing but not obligated buyer. That's hardly the case. If you look at most treaty negotiations, at least in this space, the UN recognizes 192 states. Once leaving aside Kosovo, Taiwan, and the Vatican. Once you leave the first 15 industrialized states, it's very, very poor. The rest of the world averages about 16 hours of electricity a day. Infant mortality is very, very high. Caloric intake is very, very low. There are fundamental issues with water. So there are asymmetries in these treaty negotiations. A lot of these carve-outs are unilateral in nature. So you're presented in a situation where you're representing a developing state, and the government representatives are saying, look, we have to get this done, even though this isn't favorable, but this is going to mean food, water, and all these other benefits immediately. So that's the problem with the treaty negotiation. So I think the reservations are fine in principle. In practice, they have this asymmetrical context that I think is pernicious.
And second quick question, follow-up, well, not follow-up, it's a different subject. There's a strand of case law in investment arbitration piece that examines the reasonable nexus with public purpose. Isn't that sort of like the proportionality of
Here's the problem. First of all, those awards are few and far between. And second, they don't really, what they end up doing is trying to quantify, in my opinion, what they end up doing is trying to quantify the effects of the regulatory act versus the need, the detrimental effect or the diminution in value that regulatory act imposes on, let's say, the investment versus the need for A, the regulatory act, or whether there was a least restrictive regulatory act that could have accomplished the same aim. So, it doesn't advance the ball. And at the end of the day, the problem why we feel it doesn't advance the ball is, again, because the analysis is always framed as FE, fair and equitable treatment analyses, or other investment protection analyses are framed. They're always framed in terms of property law, contract law, and the law of negligence. And it doesn't take into account the very policy objectives that public international law in this field purports and should address. Anyway, if any of you have further questions or you want to talk about it, feel free to contact us, drop us an email, and we'll keep the dialogue going. And we want to thank you for having come, and enjoy your classes. Thank you.